All right, good evening, everyone. Welcome to week 7 of administrative law. I hope you've all managed to have a at least somewhat restful, enjoyable Christmas break. I acknowledge that maybe it wasn't so restful because you had an assignment due after the holidays, but I hope beyond that you managed to get a bit of a break and that you're coming back to the term refreshed and ready to go again. I do apologize that this tutorial is falling on a public holiday. It's unfortunately just one of those things with the limited timetable spaces available. It's not really an option to reschedule. And we've got so much content to get through that we did just need to press on. So, I appreciate you guys showing up this evening. And if you're watching this later as a recording, I'm sure you'll still be able to get plenty of value out of this, and you're more than welcome to get in touch via Moodle or Teams or email. We can have a chat about any questions or comments or concerns that you've got that you didn't get a chance to discuss this evening. So a little bit of housekeeping first. Your group assignment's obviously due on Friday at 5 p.m. So I strongly recommend that you be, motoring towards finishing that if you're not already. There's already a couple of submissions in the system, which is great to see. And just really making sure that obviously towards the back end, you've got a bit of a time sink in collating everything, uploading the video submission, and then making the submission into Moodle itself. So definitely please do make sure that you are allowing enough time to get that done. If you're senior counsel, the presumption is that you're the one who'll be doing the uploading. That's the trade-off you get for Ash's issues being a little bit easier. But please make sure you're communicating with your fellow group members so that they know kind of the latest that you need all that stuff to make the upload. So, maybe even tonight or tomorrow morning, sending a quick email to your group members and say, hey, look, I need your stuff by Thursday morning or whenever it is, just so that that's nice and clear. If you're junior counsel and instructing solicitor, obviously, the expectation is that you'll be a respectful and responsible and courteous group member, and that you're passing your stuff on to senior counsel in a timely fashion. And if you can help them out, for example, with maybe some of the video editing or compiling the Word document, obviously that I'm sure that's appreciated as well. But, you can figure that out within your groups as it is. Thanks for joining us, Michael. I'm just going to pop you on mute because there's a little bit of background noise coming through. So if you do want to speak, I've muted you, so you just need to unmute yourself again. So that's housekeeping number 1. Housekeeping number 2, we do have an exam date for the end of term take home paper, and I'm now drawing a blank. I've taken on animal law for the second half of this term as well, and now I'm getting the dates mixed up, but it's either the 15th or the 16th of February. So, once we get through this assessment, we'll start to think more about that. But if you've got work commitments and things to work around, we do have a date locked in, so you can start to schedule around that as well, which is really great. That's it for housekeeping. The key thing that we want to talk about today is our sort of second broad or key ground of review, which is unauthorized decision making. And this is a really important topic. And so I do really encourage you. Obviously, there's a lot of things at this point in the term, there's a lot of things happening. And then, with Christmas and everything else. So this is a topic that I really do strongly recommend you, 1, give yourself some time with, but 2, come back to it in a couple of weeks' time when things are a little bit calmer, at least once you're past the midterm assessment and you've got a little bit more headspace with that. So, it is a tricky topic. And so it's important to kind of give yourself the space to work through it. Obviously, I'm more than happy to have a chat. So if you are feeling like you're struggling with the unit in general, but especially this week, please don't hesitate to reach out, because you would not be alone. And I'm more than happy to help out. And I think every year I explain things a little bit differently, and it's a matter of working out the way of explaining it that is going to click for everyone. So if you're having troubles, please make sure you ask, because you'll be helping other people as well. And so there's, especially on the jurisdictional and non-jurisdictional fact stuff, there's extra resources up there, and those are a product of previous iterations of the unit where different combinations of resources and different ways of explaining things have helped. And so hopefully that communicates, one, it's okay to be confused by this, and two, I think it shows that I'm more than happy to put in some extra resources and to do a little bit more to help you through what is a very difficult topic. So with that in mind, we're going to start off this evening with another little activity on the subject of jurisdictional and non-jurisdictional facts, because that really is the kind of thing that trips people up all the time. And the distinction is not always super clear in the abstract sense. But I think usually once you get kind of a more concrete example kind of down pat, it does sort of help bring it out a little bit more. So we're going to start with that, and then we'll sort of wind back a little bit to talk a little bit more about unauthorized decision making in general. So I'll just share my screen. Perfect. So you'll recognize this slide from the lecture videos, setting out essentially a sort of a classic formulation for understanding administrative power, right? If X exists, Y may do Z, right? So, if a person is of good character, the decision maker can grant a license or can approve their permit or something. What is tricky with especially X's existence is whether that's something that's objectively determined or subjectively determined, whether there's discretion involved. And so we can read if X exists in terms of X must clearly and objectively exist before the decision maker has the authority or the power to do whatever they want to do. And we would expect that if that's, I suppose, objectively determinable, that would be a jurisdictional fact. And I think what sometimes trips people up is thinking about jurisdictional and non-jurisdictional being related to the review side of things, and it is, but really what we're thinking about here is does Y's authority or jurisdiction, but think about it as authority, is it contingent on X's existence, or does it include deciding whether X exists or not? And so that's sort of the second bullet point here, is Y's jurisdiction includes determining whether X exists or not. And so what's important about that second option is that obviously Y has a lot more power. They kind of get to decide two things rather than just one. But they're also getting to decide whether the power that they have arises in the first place. And so what's interesting from a judicial review perspective is that that's not judicially reviewable, because there's that sort of subjectivity involved. The court isn't really interested in reviewing under the sort of separation of powers. So we'll talk through an example. And Ideally, what we do is I'd get 2 volunteers. We're a smaller group, so um, maybe that might not be possible. But if we've got 2 volunteers to jump forward, we can proceed that way. If not, it's not hugely problematic, but it's just a little bit clearer to do it that way.
Yeah,
I might. Perfect. Alrighty, thanks, Chris. So let's say that Chris is looking to really put in the hard study hours this time, and so he tells himself, if I study for 10 hours this week, I can choose to do one of a few things. I might go to a movie, might play a video game, I might go out and see friends, which, with COVID being the state it's in, might be tricky. But if I study for 10 hours, I can choose to do a few things. Or he might say to himself, scrap the 10 hours thing. If I decide that I've studied enough, then I could choose to get to do these things. And so if we reframe that in the sort of classic formulation that we've talked about, we can think of X being the fact that either exists or doesn't. In the first example, X is studying for 10 hours. And in the second example, X is deciding whether there's been enough study. And so, how do we figure out if X exists or not, right? How do we decide if Chris is going to get to choose to go to a movie or whatever? The first example is objective, right? We can pretty clearly tell whether that 10-hour study goal has been met or not, right? You put a timer next to the computer or whatever, but you've either studied for the 10 hours or you haven't. And so if Chris has studied for the 10 hours, then great. It's pretty clear that he can choose to do one of those things. And if he hasn't, well, then he doesn't get to, do one of those 3 things. If we move on to the second example, there's subjectivity and discretion here, right? Instead of being a really clearly determinable, 10-hour threshold, now it's that Chris just gets to decide if he's studied enough or not. And that's really subjective. It might be a lot more than 10 hours, or it might be a lot less than 10 hours. And it's not for any of us to say whether that's been enough or not. And so, say you're one of Chris's friends and he comes to see you and you're like, oh, I thought you weren't going to come out with us unless you'd studied. There's a big difference between, oh yeah, I studied for my 10 hours, so I get to come out with you guys, versus, oh yeah, I decided I'd studied enough and so here I am, kind of thing. So what this example is trying to show is that really clear distinction between something where X is objective versus where X is subjective, or whether there's discretion involved. And what we're interested in from the sort of jurisdictional versus non-jurisdictional facts perspective is where X is objectively determined, then the court is quite happy to review that. So we'll say it's a jurisdictional fact, it's reviewable, because the court is willing to look into, okay, was that threshold met? Was that 10 hours of study completed or not? If it was, great. If it wasn't, then that's a problem with the process by which the decision was made. It's not a problem with the decision itself necessarily, but it's a problem with the process by which the decision was made. There's a clear rule set out that wasn't followed. Compare that with the second example where there is that subjectivity. Instead of a really clear threshold, now it's just, Chris deciding whether he studied or not. And it's because that discretion is kind of given to him, then it's not for anyone else to really interfere with his decision whether he studied or not. Someone else might reach a different conclusion. Someone else might have a different opinion about whether there's been enough study done. But at the end of the day, that's sort of no one else's business. And when we think about that from a judicial review perspective, that decision about whether there's been enough study forms the content of the decision rather than the process by which that decision was reached. I'll pause there to quickly ask if there's any questions so far. Is that making sense? Excellent. Okay, that's good to hear. All right, we'll press on. So this is just sort of summarizing what I was saying. So, say you run into someone at the movies and they say, why are you there? So, sort of taking the place of a judicial review, we would expect the first option to be reviewable. So, that's a valid question. If you go to the movies and someone says, oh, what are you doing here? You've only studied for 5 hours. That's a fair question. That's a fair, I suppose, critique. But if someone says, oh, what are you doing here? You've only studied 5 hours and the goal was just to study enough, it's easily answerable by saying, well, I decided that 5 hours was enough, so here I am. So yeah, just highlighting the distinction between those two. And so why that's important and why that's relevant is, as I've said, this is a particular topic that really does trip some people up, and that's why I'm pretty keen to spend a fair bit of time talking about it now. But what it means especially from an assessment perspective, thinking pragmatically, is that where you can identify where a jurisdictional fact arises, so where there's that kind of objective criteria or objective need for a fact to exist, then that's inherently going to be reviewable as an unauthorized use of power. So, we're going to say if X exists and X's existence is a jurisdictional fact, if the fact didn't arise, then Y doing Z is an unauthorized use of power because Z, the power, wasn't validly exercised. The triggering condition of X wasn't there. What's important from the perspective of non-jurisdictional facts is that that's not reviewable as an unauthorized use of power. So, where you see, and I'll show you some more kind of more realistically framed examples in a moment, but where you see that discretion, your mind shouldn't really be thinking unauthorized use of power because that's going to be a non-jurisdictional fact. But that doesn't mean that we're completely out of luck. We might think maybe there was no evidence on which to base the decision, which is the topic that we talked about before the break. And then there's some other options as well. So thinking about irrelevant information or failure to consider relevant information or unreasonableness, which are topics that we'll cover in coming weeks. Those might be options that come into play as well. So we're not, in identifying that something is a non-jurisdictional fact, we're not completely out of luck, but it wouldn't be appropriate to be using that unauthorized use of power ground of review. To show you what that looks like maybe more in practice, this is an example taken from a previous year's exam. So here we've got section 6 saying if a person departed from a COVID-19 hotspot in 14 days prior, they can be required to make a COVID test or whatever. So, if X exists, departing from a COVID hotspot in the last 14 days, Y, the QCA, may do Z, order them to take a test or whatever. Do we think that that's objectively or subjectively determined, this departing from a COVID-19 hotspot in the last 14 days. Objective, perfect, yeah. And so the follow-up thought being, would that be jurisdictional or non-jurisdictional?
I would have gone with jurisdictional.
Yep, absolutely, perfect. So yeah, if someone departed from a COVID-19 hotspot 3 weeks to 21 days prior, then they don't meet that threshold that's clearly and objectively determined. And so if they were, required to go into hotel quarantine or something, we would expect that could be reviewed. We can contrast that with Section 7, which provides that if, in the opinion of a QCA officer, a person is likely to have COVID, they can do blah, 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 blah. So here what's key is the opinion of a QCA officer. That introduces that subjectivity, and it means that it's not an objective question whether someone has COVID-19 or not. Instead, it's a subjective opinion of the QCA officer whether someone might have it or not. And so, they might say, well, look, he coughed near me, so I thought he had COVID. And that's from the perspective of unauthorized decision making, at least, not reviewable, because that's enough for the QCA officer to form an opinion that someone's likely to have COVID-19. So subjective, non-jurisdictional, and therefore non-reviewable from the perspective of unauthorized decision making or unauthorized use of power. So that's a little coverage of jurisdictional and non-jurisdictional facts, and I'm hoping that will be a useful kind of resource. I don't think those slides are up at the moment, but I can pop those up on Moodle as well. And I'm hoping that will be a useful kind of reference point for you when you circle back to this topic with exam revision and stuff as well, because it's a tricky thing to get your head around, and it is something that definitely trips people up. So hopefully having a few more concrete examples will assist with that. Any other questions about jurisdictional and non-jurisdictional facts, but also unauthorized decision making more broadly before we move on? Cool. I'll take that as a no, and I'll just make a few more brief comments about unauthorized decision making, and then we'll jump into the hypothetical question. So I think the really key thing about this ground of review, obviously, is that it goes to the authority of the decision maker. And so really what we're asking ourselves with this ground of review, for one, is what is the decision? So, what did the decision maker decide? And clearly the, reasons for decision and access to information stuff is going to be important to that. And then what we need to do is think about, okay, well, were they allowed to make that decision? And so ideally what we need to be able to do is, or, what the decision maker should be able to do is point to the particular section or provision or whatever that specifically enables them to make the decision that they made. So, especially where facts might be jurisdictional, demonstrating that their power arose, and then demonstrating that whatever decision they made was actually, validly provided for in the Act. And that, comes back to this idea of the principle of legality, that decision makers and the executive branch of government more broadly can only do what Parliament allows them to do. So with that in mind, the three kind of things that we're interested in for unauthorized decision making are issues where that authority, there's a problem with that authority, and that problem infects the decision that was reached. And so what we're thinking about is where the proper procedure wasn't followed, where the decision maker didn't have jurisdiction, so that distinction between jurisdictional and non-jurisdictional facts, or for some other reason the decision not being authorized. So perhaps, the decision maker might be allowed to do A or B, but they did C instead, and that's obviously going to be problematic as well. So thinking about those sort of three categories as being quite key. And so what I'd suggest you do, and again, this is probably something to revisit later on in the term, I'd sort of scaffold your thinking around this topic by first thinking about, okay, well, what's the decision maker required to do and or allowed to do? Second, therefore, thinking about, okay, well, what are the procedural elements of the legislation? What are the jurisdictional elements of the legislation? So where in the legislation does it set out what the decision maker can do and what do they have to do? And then third, we sort of flesh that sort of frame out by thinking about, okay, where there is a procedure to follow, is it mandatory or is it optional? Where there's a particular fact that's important, is it jurisdictional or not? And so really layering those ideas on top will help you think through what's going on here, basically. So let's take a look at that in action with this week's tutorial question. And this one is an extended question, which is similar to the kind of style that you've been given for the midterm, and that will be repeated at the end of term exam as well. A bit more detailed, key bits of legislation given, all that sort of stuff. So this scenario here, we've got the Gaming and Casino Licensing Act, which regulates gambling services. You need to have a license, you need to have a dedicated gaming area, and you have to, it's an offence to possess alcohol in a dedicated gaming area. This is a made up bit of legislation, by the way, just for the purposes of this week. So there's this gaming licensing authority that administers all these kind of restrictions and requirements. Under Section 26, they can conduct a disciplinary inquiry. And under Section 26.3, they have to give 28 days notice that the inquiry will take place. 26.4 says that they can announce themselves to the venue, the officers, but they don't have to. And then we've got some further provisions which outline, what can be done, what disciplinary action can be taken, and then some review options that we'll think about as we go through. In our scenario, we've got Poe Kerr, who has a license. There's a random inspection, and the inspector finds that several patrons have brought alcohol into the area, and that 2 employees have allowed the patrons to drink that alcohol in the gaming area. So they write to Poe and say that the 2 employees need to have their employment terminated. And so we need to advise Poe and Rue what their options are. So the first question is whether the avenues of merits or judicial review are open to either of them. We'll skim through that one. It's important to cover, but we'll skim through it. And so that we can get to some of the substance of some of the other options. So I'm conscious that, the place that this tutorial is taking place in terms of being up against the holidays, being up against the assessment due at the end of the week. But did anyone, I don't want to, I don't want to overcrowd the discussion, I guess is what I'm saying. But at the same time, I recognize that, some of you or all of you might not have had a chance to work on this one. So I'm going to open up the floor, but I'm also more than happy to run through things if we need. So any thoughts initially on merits and judicial review in this question?
I wouldn't mind having a go at this because I've
of course.
read through. When I originally read it, I was quite sure that it was a merits review. But when I started to go through the details of what the authority had the ability to do and what the legislation said, under S26, all the action the authority could take was specified towards the licensee. So disciplinary action was towards them. So looking at that and the fact that he's been directed, even though it says under S29D that they can actually set a requirement, the requirement is overstepping, in my view, their regards for what they should be allowed to do. So I would have thought it would have been open to the ADJRA, and that they would have a justiciable path forward, because the authority has the thing to go after the licensee, but they can't say to them, well, you can't hire these employees. They could say, you couldn't, but this is my view, is that they could say, well, you can't work in this area, but they can't just say you've got to terminate them as a requirement. I just felt they were overstepping their authority under that act. That's how I took it.
Yeah, those are some interesting points. I think really the substance of that is sort of skipping ahead a few points. So we might park those. Those are good points to raise. But I think the initial thing to think about in terms of merits review and judicial review is firstly to think about, okay, so the AAT merits review is the AAT can only review a decision if the primary legislation allows it. Here we've got section 41 allowing for application to the AAT for review of a decision, but it only relates to 3 specific scenarios. So A, refusing an application for a license under section 18, B, the issuing of the license on terms or conditions to which they object, or C, suspending or cancelling a license under section 29. And what's difficult for us in this scenario is that the disciplinary action that's being taken is, well, for one, it's not relating to the issuing of the license. For 2, it's not a refusal of the application. But it's also not a suspension or cancellation of the license under section 29. That, there's the direction in relation to terminating the employment of Jack and Roo, but that doesn't go to the substance of the license itself. And so the conclusion that we would reach is that a merits review to the AAT would not be available in this scenario. Now, that's a little bit tricksy. It's more tricksy than I would I suppose stoop to in an exam, but I think it's worth thinking about in a tutorial question to be really paying attention to what is and isn't allowed in that merits review setting. Thinking about judicial review, we would definitely expect that judicial review would be available, right? And so thinking about justiciability, which Chris mentioned, Jack, so Poe's right to employ or fire whoever she likes is clearly being impacted. Roo's right to employment is being affected, and so we would expect that this would be a decision that the court would consider justiciable. it's a decision of administrative character made under an enactment and not excluded under the schedule. So we kind of meet those formal justiciability requirements under the ADJR Act. And we would definitely expect Poe and Roo to have standing in a commercial sense, right? They've got an interest in this decision beyond what the average person would have, quite clearly. So we would expect judicial review to be available. We would not expect merits review to be available, which is, an interesting and useful distinction because of the nature of what's been decided. The second question being, should they take any steps? Yes, they should. They should get the the full reasons for the decision, and potentially we would like to see some further evidence or documents obtained via FOI. We'll talk about what those are as we go through question 3. So question 3 is, on what basis, if any, can they challenge the validity of the authority's decision that the grounds existed to take any disciplinary action? So this sort of relates to the process under section 26, and then section 27 as well. The following are grounds for taking disciplinary action against a licensee. So I think some of what Chris said sort of touched on some of those ideas, but maybe we can have a more, I suppose, direct conversation about on what basis we'd look at challenging that decision. So thinking about, in terms of unauthorized decision making, were there procedures required that were not followed? Did the decision maker not have jurisdiction to make the decision? Or was the decision not authorized by the enactment? So we might start with procedure not being followed. Can anyone briefly tell me what the 3 kind of questions we need to be asking ourselves when we think about procedure not being followed? So these kind of steps or questions come from Project Blue Sky. And basically what we need to think about is, 1, does the Act specify a procedure? 2, was that procedure breached? And 3, is it the purpose or the aim of the statute that an act done in breach of the procedure be invalid? So is that procedure mandatory or optional? So if we think about, and we're given some clues in section 26, is there a procedure that needs to be followed in this instance? I might, I'll share my screen so you've got access to it. So here, under section 26, the authority can conduct a disciplinary inquiry. Section 26.3 sets out the procedure. And so here, the key things that we're interested in, for 1, 26.3 says that the authority must provide at least 28 days notice. And for 2, the officers may announce themselves to the venue, but are not required to do so. So here we've got 2 procedures outlined in the Act. For 1, 28 days notice, and 2, announcing themselves to the venue. It's an open question, I suppose, whether those procedures have been followed in this instance. Based on the facts, it doesn't seem like, we don't know for sure, but it seems like maybe the officer didn't announce himself to Poe or at the venue. But whether he did or didn't isn't entirely problematic, because we're told that they're not required to do so. This is a procedure that's laid out in the Act that's not mandatory. It's optional. And so not following that procedure is not problematic or fatal to the validity of the decision. However, this 28 days notice that the inquiry will take place, must is the key word here. And so we would expect that if that notice hadn't been given, then, that's starting to sound pretty mandatory, and it would therefore be probably the intention of the Act that if that notice isn't given, then the subsequent decision that's been made about the disciplinary action would be invalid. So what we would need to know, if Poe is our client, we could just ask her, but it would also be good to confirm it via a Freedom of Information request, is to check whether that notice was given. And it's possible that Poe got it and forgot about it or whatever. But going via the Freedom of Information route, if we thought that the notice hadn't been given, going by that FOI route would help to confirm, if no such document existed, then that would confirm that the notice hadn't been given. So that's something to be thinking about as well. But what I'm suggesting to you is that this 28-day notice is a procedure that needed to be followed. And if it wasn't, then potentially, this is, everything that followed is invalid because of that breach of the procedure. And so that's potentially one way of reviewing or challenging that decision. Does that make sense?
If you were writing a submission in that regard and they had breached that side of things, do you then need to worry about any other aspects of the application, or would you just focus on that? Or would you say, well, this didn't occur, so therefore it didn't happen, but if it was considered to be, and you'd still go through the other issues, what sort of approach do you take there?
In both cases, I would say keep going anyway, because certainly from an assessment perspective, you talk about other stuff too, because it's all accessible and it's all potentially relevant and all that sort of stuff. From a more practical perspective, I would still suggest that where, especially if there's other grounds that you think you'd succeed on as well, it's definitely worth raising them too, just in case, on some random off chance, it was found that the procedure somehow wasn't breached. You rock up to trial and they've miraculously found the letter that was sent or something, or it's decided that the wording's pretty clear, but it still wasn't the intention that a breach of this procedure invalidate the decision, something like that. It's safer to kind of cover your bases and think about other grounds of review as well if they're relevant. So let's failure to follow the procedure potentially. Let's think about some of the other options. So thinking about jurisdictional and non-jurisdictional facts. I'll cover that one really quickly and point to So, the key thing here is that, the authority has a lot of discretion. So first, if they're satisfied that there are grounds for taking disciplinary action, they're given some guidance about what those grounds might be that they need to satisfy themselves of. But 27C, it's being managed in a way that makes it desirable that action should be taken. That's so broad that could cover, a lot of stuff. And so what I'd suggest to you is that together, sections 27 and 29 give the authority a lot of discretion, and therefore we would expect that would be non-jurisdictional and not reviewable. So we'll skip over that one, and we'll think more closely about whether the decision was authorized. So this decision in section 29 to require the termination of an employee, whether that's authorized by the enactment. And from your comments earlier, it seems to be that you think, Chris, that wouldn't be authorized.
Well, I wouldn't have thought so, because it's all based on what the licensee is supposed to do, because he can hire and fire whoever he wants. They could put a requirement that they're not allowed to work in that area where they've got a monitor liquor being in there. But I wouldn't have expected that they had the right to be able to say, well, this person is, you've got to terminate these people, especially keeping in mind that then it would trigger off something like Fair Work, etc., where they could then sue the individual. That's go after Poe, basically. I just didn't think they would have that sort of authority.
Yeah, it's a tricky one, and what makes it tricky, I think, is that we would expect sort of, I suppose, intuitively that it doesn't quite seem to fit with the intention of the Act. But also what I think is really interesting and what's important about this 29D is that they have to comply with a requirement specified within or for a specified time. And so potentially, and perhaps we need a little bit more information about the decision, but potentially that could be satisfied if, so, it's pretty clear that terminated employee is a requirement. We might not agree that it's a necessarily fair or appropriate requirement, but it's pretty clearly a requirement. But what might be ambiguous and what we might need more information on is whether it's required within a specified time. So, what they could have done is said, you need to suspend these people for 3 months or something. And that might be, that might fall within the requirement for a specified time. But to completely, I suppose, permanently terminate someone's employment seems to go a bit further. And in particular, what we'd be interested to see is whether it was within a specified period of time. So, if they said, you need to fire these people within a month versus you need to fire these people and it's left open the time frame in which to comply, potentially then we've actually got an argument that the requirement doesn't actually fall within the authority under section 29D. That's a pretty fine thread to try and get through the needle hole there. But if we had more information, that's potentially one option that we can be thinking about. What's perhaps more useful or relevant is to think about, all these other requirements really attached to the license itself. And don't necessarily attach too much to the way the licensee conducts their business in terms of day-to-day operations. And so what we might try and do is take a more, I suppose, principled argument and sort of think about, okay, under the principle of legality, we know that the decision maker has to be given quite clear and explicit authority. And then second, thinking about the decision in Paul and Monday. So that was the decision about regulating the air pollution and so the power to regulate air pollution didn't include the power to regulate fire, even though fires create air pollution. There's this really interesting distinction laid out in Paul and Monday that, you know, a power to do one thing on one subject matter doesn't include the power to do something else on a different subject matter, even if there's a really clear connection between the two. What we could do is we could use that, frame the argument in that way to think about, okay, the subject matter for this power is regulating gaming and gambling. This decision that we've been given is about a different subject matter. It's about employment. And so what we could do is argue, following Paul and Monday, that the decision is not authorized because it's about a different subject matter than what the decision maker has been given authority to do. You know, it's, as I said, it's a bit more of a broader or more principled argument, but what's quite, I think, neat about it is the way that it reframes what the decision is and what the decision's about. And that's really important. And that's why sort of, you know, earlier I was encouraging you, when you think about this topic, to really think about, okay, what is the decision? What has been decided and how has it been decided? Because that's the kind of thinking that opens you up to these kind of possibilities and will make you think, okay, you know, on the surface, it seems to be about this, but can I think about it in a way that makes it about something different? And if you can do that, then yeah, potentially you do get these other options available to you. Does that one sort of make sense? So basically what we're doing is we're arguing that the decision is not authorized by an enactment because the decision is about a subject matter different to what's been authorized under the Gaming and Casinos Act. I'll take that as a yes. Are there any other, so that then sort of takes us through basically what we would be doing is we'd be arguing, for one, the procedure wasn't followed, if we can get more information about that, and for two, potentially this is a decision that's not authorized under Section 29 because it's about a different subject matter. Any final questions, comments, or concerns before we wrap up this evening?
Jacob, just about the assignment.
Yeah, of course.
I've done the first part and I realized I've kind of made it like a letter of advice to the client when it's supposed to be to the AAT. Is it worth rewording it slightly in order to make it definitely to the AAT? Am I going to lose a lot of marks?
Not a lot, but I would definitely recommend that you make it pretty clear, because you know it's there's a little bit of leeway, but yeah, it's in terms of framing arguments, it needs to be framed as, you know, this is how we would like you to see things versus this is what we would argue. You know, there is a bit of a distinction there. And so, yeah, in terms of, you know, the criteria for structure and flow and written expression, yeah, I would suggest that you do dive back in and tweak. It shouldn't take much tweaking, but I would say that it is well worth doing. Yeah.
Okay, thanks.
Perfect. Alrighty. Well, thanks for coming along. Enjoy the last few hours of the Christmas, New Year's holiday period, and best of luck completing those assessments. And I'll see you guys next week. Thanks very much. Bye.